Hi, Massad. Good to have you here.
Oh, it's good to be back, Hila.
I appreciate you being willing to answer my questions, most
I'm
of anything.
always willing to answer your questions.
You know, one of the things that
Am I being
hear,
detained?
no, sir. One of the things that I get asked a fair bit about goes to the question of attorney selection. But I think that it's deeper than that, and I think that you've got some of the insights that we need to know. And so, laypersons like me, we watch the news, we read the books, we read the articles, we even watch the streaming video, and we see these trials of what looks to us as innocent people just going off the rails. And then I think we ask ourselves in the privacy of our own minds, if that was me sitting in the defendant's chair, what would I have done? How would I have gotten that train wreck stopped? How would I have interrupted the process? How would have I avoided even being there? I'm not necessarily talking about not getting in the self-defense situation because I want to be alive to be there. But are there things I can do as far as preparing my legal defense? And so today, for those of you who may not know him, this is Massad Ayoob, and he has agreed to discuss mistakes made representing innocent people. And I guess let's start by asking, what is your history with the legal defense of self-defense, Massad?
Well, basically, arresting officer since 1972. From 1988 to my retirement in 2017, I was a police prosecutor in the New Hampshire system. We were non-attorneys who prosecuted our own cases at misdemeanors and violations, and we could take felonies up to arraignment level and could second share with the regular prosecutor on felonies if they so desired. I've been an expert witness for the courts since 1979 in cases involving weapons, use of force, primarily homicides, and most of the cases that I do are self-defense.
How much is your split between private citizens using force and self-defense and police-involved
In my
incidents?
experience, I'm about equal between OIS, officer-involved shootings, and private citizen self-defense shootings.
Interesting, because I mean, I think for our clientele, really, we're as interested in the private citizen side of things, and yet I think that sometimes the police-involved cases inform how we might defend a situation like that. There might be even, I don't know whether it be case law or circumstances that we can say, well, maybe that attorney should cite this authority. Maybe that attorney should use this strategy. And I think that's very much what we want to get your insights on today. And one of the things that I always wonder is how far in advance can we see a problem with, and I'm not necessarily talking about ineffective assistance of counsel, I'm talking more about strategy that just doesn't serve me as the innocent person. How far in advance can we detect that going off the rails, and what should we watch for?
Well, to stay on the rails, you want to make sure you're on the right train.
Okay.
It'd be a real good idea before you're ever involved in a shooting to find out what attorney in your area specializes in that type of case. Now, most of the time the system works. Most of the time innocent people are recognized as such. The justified shooting is recognized as such. And the ones we read about and the ones we train for are the exceptions to the norm. To find someone who is familiar with the self-defense type shooting, the best thing to do is look around and see what attorney the local police, the local sheriff's department, keep on retainer to defend one of their officers if they're criminally charged in the wake of a shooting. Now, certainly police and civilian will have different dynamics, but in the end, a self-defense shooting is a self-defense shooting. An attorney who's done a lot of police cases understands the dynamics that have to be established, understands the elements of what we call today force science, the dynamics of violent encounters, which are not taught in law school. They're learned in court, and they're learned in CLE, continuing legal education, for practicing attorneys. If you can find that attorney, it's not going to matter much whether you are carrying on a piece of tin called a shield or a piece of celluloid called a carry permit. What's going to matter is, was there genuine danger? Would a reasonable, prudent person in your position have recognized it as mortal danger? And would they have acted as you did? Were your actions within what the courts call the mainstream of custom and practice for dealing with that particular type of crisis? And ideally, will show that latest buzzword of the courts, that you acted to best practices. Now, an attorney who's defended a whole lot of cops who shot criminals in self-defense pretty much knows the dynamics that have to be established for a jury when a private citizen has shot that self-same violent criminal in self-defense. Not all, in the big cities, there have been so many unmeritorious lawsuits and criminal charges against police that there are whole law firms that do nothing but sue police departments. On the defense side, there are now whole firms that do nothing but defend police in these cases. Porter Scott in Sacramento, Manning, Marder, and Wolf in Los Angeles. But even if the attorney that represents your cops does only police, he or she will know who knows what they know and will take a civilian client, a private citizen client. So the first step, get someone who knows how to do this type of case. Don't make the mistake of looking for the most famous criminal defense lawyer. They probably got famous by pulling rabbits out of hats and finding some sort of reasonable doubt to acquit obviously guilty people. What we're looking at here is what's called an affirmative defense. We're stipulating, yeah, we shot him, but we're maintaining that it was absolutely right for us to do so. This requires a strategy that's almost 180 degrees reversed from the typical guilt mitigation of the typical guilty client, who is the bread and butter of the typical criminal defense law firm. For example, a standard thing with when you know the client's good for it or he's guilty of some lesser offense, the defense lawyer doesn't want to put him on the stand. What can he possibly say that's not going to either dig him deeper or commit perjury, which is another felony by itself? And if he perjures himself on that witness stand, there's a distinct possibility that attorney would be looking at charges of subornation of perjury, that is, having advised or exhorted someone to lie under oath. And that's a felony in and of itself in my state, and it could cause them to lose their bar ticket in any state. So it becomes a default, I don't put my clients on the stand. If I had shot someone in self-defense and the attorney I was interviewing said, don't worry about testifying, I never put my clients on the stand, I'd say, thank you, how much do I owe you for your time, goodbye. Because he's just told me he's got no clue how to do an affirmative defense. It's not a whodunit anymore. We all stipulate, you done it, you shot him, we're stipulating to that. It's now a why did he or she do it? And if you think about it, who besides the defendant can truly fully answer that question? Now, we've had a few cases where we couldn't put the witness on the stand. We had one in the Miami area. The defendant's cardiologist told the defense attorney, look, Will's condition is so precarious. If you put him on the stand, you may win your trial, you're going to lose your client. His heart will not withstand that degree of stress. And we had enough circumstantial evidence that we were able to kill the case without it going to trial. And he now has a concealed carry permit and now is still alive, which he wouldn't have been if he hadn't pulled the trigger. We've had more than one where it was a battered woman who had killed the abuser. And if we put her on the stand, if you understand that the battered woman syndrome is properly called learned helplessness. They've learned to survive by telling a brutal alpha male whatever he wants to hear. We're now going to put her on the witness stand to be cross-examined by an aggressive alpha male. It would be like feeding an antelope to a lion. In cases like that, we have been able, with enough other evidence, fact evidence, circumstantial evidence, forensic evidence, to still win the case. But it's much more of an uphill fight if the jury can't hear from the defendant the answer to the question, why did you pull that trigger and end that man's life?
So there's an expectation there in the jury's minds that the defendant will speak in their behalf?
There is, and the judge will instruct the jury to take no inference from the fact that they're not testifying. But the judge's instruction cannot overpower human nature, conscious or subconscious. The human being feels that the accusation that's unanswered, the silence is seen as a tacit admission of guilt. And it creates a more uphill fight for the defense.
It seems like such a balancing act because we feel like we're way outside of our own depth, and indeed we are. We turn to the attorney who presumably spends her or his life in the courtroom. And while I'm not going to use the word defer, I think we do want to take advantage of that experience. So you get the lawyer who says, I don't think you should get up on the stand. How big of a red flag is that? How do we weigh?
If they tell me, I know I've done the right thing,
Okay.
and they tell me, I'm not putting you on the stand. I hear them telling me, I think you're so weak and stupid you could be led wherever a cross-examiner wants to lead you, or I think you're guilty, or I think you're some crazy gun nut, and if I put you on that witness stand, you're going to turn into a werewolf in front of the jury. And I'd rather not put my life in the hands of someone who doesn't respect me.
Okay.
The other thing you've got to remember, over these years with all these cases, with the 2 years I spent as co-vice chair of the Forensic Evidence Committee for National Association of Criminal Defense Lawyers, I've met a great many defense lawyers. Yes. They tend to skew very much toward the blue side of the political spectrum. With that, in a time of political identity, people who perceive themselves as progressive, even if they've never thought much about the gun issue, if it comes up, they think, it's the pigeonhole mentality of political identity. I'm a progressive, therefore let me check, yep, I'm anti-gun. A whole lot of them find a gun person as repugnant to them as if the judge had assigned them to defend a child pornographer or something. And that makes things difficult because an attorney cannot hide from the jury the fact that they don't respect their own client. And it makes them reluctant to handle the evidence. Again, the analogy, picture if you had to handle the evidence in a child porn case. And that attorney is going to have to understand how guns work, how weapons work, how self-defense works, or they're not going to be able to educate that jury. It would be nice if beforehand you could find that attorney who represents the cops, buy an hour of their time, and ask them questions like, what is the common term for it is the mood of the courts in your particular area towards self-defense shootings. And often the mood of the courts means the mood of the current prosecutor. Now, I just came here from Alaska where they appoint the judges, and I frankly think that's a pretty good idea. In most of the states here in the lower 48, judges are elected,
Yes.
and they become sensitive to political issues too. Prosecutors are elected, and I'd kind of like to know whether the prosecutor in my community is the kind of guy that Friends of NRA invites to give the keynote speech at their annual meeting, or if he got $500,000 from George Soros to run for his campaign. Because in the latter case, he's going to need someone he can make an example out of to prove to the benefactor that it was a worthy investment. And keep that in mind, Mr. Soros, when I run again in 2 years. So those things are useful, and that's something that your attorney can tell you. If I had an attorney who said, no, I don't talk to the clients before, wait till you commit a crime or something. Okay, you're not willing to advise me things that might keep me out of trouble beforehand. Tell me again why I should be giving you money and you should be representing me.
Yeah, it's a tough spot. So you've got the attorney who, and maybe it's not even told you, maybe they have just made a blanket statement. I never put my guy on the stand. I never put my client on the stand. So that's a red flag, if not a complete no. You mentioned something about the attorney being able to explain how guns work or understand those dynamics, but aren't we wandering a little bit into the territory of they may not know, but how do they find out? And now we're talking about the job of the expert. Right. What is the willingness and what is the their attentiveness to what the expert tells them, and how do I, as the client, gauge that?
One thing to look for, if I was paying the attorney, I'd want one that I was paying by the hour. When they give you a flat fee, and now you need expert testimony, well, that expert testimony is coming out of their flat fee, so it's coming out of their pocket. And X number, for that reason alone, won't bring in experts when you desperately need one. Whether it's an expert in dynamics of violent encounters or a forensic pathologist to explain, no, that gunshot wound did not enter in the back and exit the front, it entered the front and exited the back.
Yeah, that's important stuff. So supposing that we were already post-incident and we had a guy or gal representing us and they said, I don't think I need an expert on this. Is that a red flag that gets us headed to the door?
Well, there might be cases where they don't need an expert. Okay. Where you would need one would be if it was disputed whether the bullet had entered front to back, for example. The guy has been shot multiple times. The attorney, like the jury pool, grows up, most of their knowledge about guns, gunfighting, and self-defense is what they got from TV and movies. And, you know, in the old days, the old noir movies or the old cowboy movies, there'd be one shot fired. There wouldn't be a drop of blood, but after the one shot, someone would go, ooh, and swoon to the ground. And then, you know, by the 60s, we had the Sam Peckinpah movies and the Dirty Harry movies. And one shot from the gun, hamburger flies out of the body, and the guy goes flying through a plate glass window. You shot him 7 times. You shot him 8 times. Malice, malice, murder, murder. And they may genuinely believe that. And your defense attorney may genuinely believe that. The experts, whether it's an expert in homicide investigation, scene reconstruction, dynamics of violent encounters, what we call today force science, would be able to testify that it's not at all uncommon for a man in a state of rage or under the influence of certain drugs to take bullet after bullet after bullet before they finally stop trying to hurt decent people. So in a case like that, you definitely need expert testimony. When you went bang, 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 you spun away and you stopped shooting, and then the pathology report comes back and you hit once here, and once here, you're going to need someone to explain the intersection of the time-space continuum, the dynamics of the violent encounters, that you're firing at a rate of 4 or 5 shots per second as fast as you can to save your life. He can turn in a quarter second and his lateral midline passes your line of trajectory. And you didn't realize that because by the time you saw he had turned and stopped shooting, the gun had already gone off 1 or 2 more times. No jury is going to figure that out by themselves, but someone has to explain it. And they don't teach that in law school. You may have to be the one to explain to your attorney why you need experts to explain that. One of the big things I find the lawyers missing is constantly bringing the jury back to the speed at which the actual incident occurred. The curse of it is the shooting itself takes seconds. Perhaps the decision to fire took a single second. But from the first telling of it, it takes longer to describe it than it took for it to happen. And now the weeks and the months, and in these cases, particularly the civil cases, even years have gone by. Days have gone by in the courtroom where that single second was under discussion. And it creates the false illusion in everyone's subconscious that it happened in slow motion, like the Sam Peckinpah movie, and you had all kinds of time to do something else or think of something else, or perhaps talk to him and try to de-escalate. De-escalation being the art of trying to be reasonable with the unreasonable. One of the things we need to do more than many defense attorneys do is constantly bring the jury back to the unforgiving speed at which those things happen. And that's one thing you can do with expert testimony. In line with that, everyone is focusing on what you did. You fired that gun. You fired these bullets into this man's body. The jury's seen the autopsy pictures, usually carefully arranged so the prison tattoos aren't visible. And it's all about what you did to him.
Hell, you admitted that you shot him.
Yeah, and they hear that as a confession to murder. A whole lot of people out there think homicide and murder are 2 words for the same thing. And the opening statement, they've heard your attorney say, my client shot him.
Yes.
They hear that as a confession to murder. We have to explain to them that, look, I want to convince them that if Mother Teresa had been there, she would have picked up a gun and shot this SOB. But we've got to show, look, they say it was unfair that you shot him because he only had a knife. I've heard that so many times I want to throw up. We need to be able to explain that knife never runs out of ammunition. That knife never jams. That knife comes with a built-in silencer. You can run it as fast as a Singer sewing machine almost. With a movement like this, you can literally eviscerate a human being. And they can open you up like a zipper bag. The public has this misconception that I call the myth of the hierarchy of lethality. That the gun is up here, it's the deadliest of all handheld weapons, it's so deadly President Biden wants to ban it. And the knife, yeah, we know consciously you can stab somebody, but look, I cut my steak every night with one, I open my mail with one every morning, and they don't see it as a weapon. And we need to be bringing back and show how dangerous it is. Every time someone tries to crush a policeman to death with their automobile, and a cop shoots them, invariably the next day the newspaper headline is "Unarmed motorist gunned down by police." And I tell departments, you need to be showing have the medical examiner come in, show your officers, here's, among other things, here's what it looks like when a human being is hit by an automobile.
Yeah. Talk about blunt trauma.
Being strained through the grill is not a figure of speech. And a lot of these we find human flesh, body parts inside the grill, inside the engine compartment, up under the fender where they were spun by the wheel when it was torn off the body. And we need to explain, look, if that cop was carrying a 357 Magnum, let's say, 583 foot-pounds of energy with a 125 grain bullet at 1450 feet per second. Oh my God, look at this horrible mangling injury that they did to the unarmed man. We need to remind them an automobile at 50 miles an hour is exerting 500,000 foot-pounds of energy. And I tell them, you take one of your trained accident reconstructionists, use the exact same formula we use to determine energy in pistol or rifle bullets. Get the gross weight of the vehicle plus the weight of any people on board. Your accident reconstructionist can determine the speed at which it was going. And what you're going to find out is that so-called unarmed motorist who was trying to crush that officer to death was exerting more destructive foot-pounds of energy than if that officer had fired every round of ammunition on his belt. Usually we can show if every officer in the precinct had emptied their gun and every round of ammo on their belt, it still would not have equaled the destructive energy that was being directed against that officer when the shot was fired.
But how is the description, it seems to me it has to be kind of carefully tailored, because how does that description of the potential damage to that officer not become mere supposition, just a fiction created?
Well, it's not supposition. The question is not, it has to be framed. The question should not be on direct by your attorney, what would have happened. It should be what could have happened.
And you're allowed to speak to what could have.
Absolutely.
Okay. Interesting, fine point. But it calls for that skill set. It calls for that experience. And now we get back to that. Do we have the guy who's had 50 murder trials, but maybe not people of my ilk?
I'd rather a guy who had 10 self-defense trials than 50 murder trials.
Okay.
I want someone who knows how to defend an innocent person. What I found over the years was if a guilty man's lawyer, when I say guilty man's lawyer, everyone has a right to defense.
Yes.
But if they've spent their time mitigating guilt when they know very well the client's guilty of the crime accused or of some lesser included offense, it becomes their default. And they start defending an innocent person with the same guilt mitigation strategies they'd use for the guilty client. And what I found, if a guilty man's client gives you a guilty man's defense, you're going to end up with a guilty man's verdict.
And that's how we get those things we read about that we say, how the heck do I stay out of that? How the heck do I stay out of that situation? So we've got the willingness to do the affirmative defense versus the guilt mitigation. We've got the use of those, well, it's really the active dynamic, to go back to a phrase you taught us many years ago, the ability to take that focus off of you doing the shooting to why you did the shooting. What else does that attorney need to focus on?
Well, again, constantly reminding the jury of the speed of it, reminding the jury that when they're deliberating, every minute they think about it is 60 times longer than the 1 second the defendant had. And that's got to be taken into consideration. And the United States Supreme Court has said so. In Graham versus Connor, the guiding
That's a
light
long
for
time
police
ago.
use of force, the court spoke of the tense, rapidly evolving circumstances that the officer faced in such situations and instructed that that must be taken into account. Said also expressly that 20/20 hindsight could not be applied in exigent circumstances such as these. And we need to be emphasizing that more than some defense attorneys do.
Do you remember what Chris Farrow said about his defense of Spencer Newcomer? He talked about how he put the picture up on the screen just for that instance that Spencer had that moment to determine whether what was coming out of Wintermeyer's pocket was a gun or, as it turned out to be, a cell phone. And of course, just as you said, it went by really fast.
And that was brilliant.
I remember Farrow saying, well, we had to take a chance, and I don't think he was wholly confident how it worked out. It worked, as you said, brilliantly.
Spencer Newcomer was acquitted.
Yes, and that's
Marty
another.
Hayes did a great job as the expert witness in that case.
Well, I'm glad to hear that, and you know, we're pleased that Spencer's not in prison. Goodness sakes, he's suffered enough. But it goes to that kind of gut check that the attorney has to make. Shall I take this chance? And yet he knows, just as you said, that he's got to show the speed with which it happens.
Reconstructing, letting the jury understand the terrible danger that the client faced. Reasonableness is demanded by the courts, both objective and subjective. Objective being the standard guideline of the reasonable person doctrine, the three-pronged test of what would the reasonable, prudent person have done in the exact same situation, knowing what the defendant knew at the time. And also the subjective reasonableness, did this defendant truly believe that they were in deadly danger? And without the defendant testifying, it's kind of hard to establish that.
Well, and the other things have helped establish that. But we've talked a lot about going to trial. What could be done by the skilled attorney, by the attorney with some courage that way, to prevent having to go to trial?
The dirty little secret of this is when it's properly handled, how often the case is killed before it goes to trial. And again, it's a part of the dichotomy of guilt mitigation versus defending the truly innocent person. So many defense lawyers will say, don't give the other side any more than we have to, hide the ball. I keep hearing the phrase, save your best moves for the dance, right, for court. Well, that's all well and good, except if the truth is on our side, we let the other side know up front. Now, it's highly unusual for a defense lawyer to call the prosecutor and say, hey, my client wants to talk to you. You know, they generally do a double take because it's uncommon. After you've sorted things out, the client has calmed down, and you've figured out what the heck has happened. We recommend they come in with the attorney, of course.
Oh, yes.
Let the prosecutor and their investigators talk to him with the defense lawyer present. Record the whole thing, sound and video. The reason I say video is that sometimes our communication is more visual than audible. And, you know, if you said something sarcastic, the video capturing the facial expression, you'd know it was sarcastic. If it's just the words, it could be misinterpreted. And what we found very, very often, the other side says, okay, we had not seen it from that perspective, or we had not known about that element. Thank you for coming. And sometime between the next day and a couple of weeks later, the case goes away. In 45 years as an expert witness, I have twice had periods of 2 years where I didn't have to set foot in a courtroom because each time it was killed pre-trial.
But you still had an ample number of cases that you were working on.
Oh,
It
yeah.
just didn't go to trial.
Yeah.
Interesting.
And that, of course, saves a great deal of grief, a great deal of angst, and a great deal of expense. If you know you've done the right thing, you think the evidence is going to show you did the right thing, and your attorney doesn't want to sit down and talk to the prosecutor, I'm not going to accuse anybody of bad motives, but bear in mind, if you kill it before trial, the attorney doesn't get to charge you $100,000 for the trial.
Well, that's an uncomfortable balance because, especially in the case of the network, where we're paying for the members' defense. I mean, certainly we're not going to cheap out on them, and we got a history of not doing that. But by the same gesture, I think we do have to look at that, not only that person's own well-being, but the well-being of their family. If they have children, if they have elderly parents, what are those people going to be put through in their community with the.
In the course of these cases, I generally meet not only the client, but often their family.
Do you?
And when you see the agony they're going through, wondering, whether they're going to see their son the next time on visiting day instead of at home, it's heartbreaking. The sooner you can kill that, the sooner you can get the truth across. Basically, if you've looked at defensive gun usages themselves, the vast majority of them end when the defendant, the good guy or gal, presents the gun. The bad guy realizes, holy crap, I've bitten off more than I can chew and I could die from this, and they run away.
Yes.
A whole lot of the same principle applies here. If instead of pulling a gun on your attacker, you pull a large caliber attorney on your accuser and let them realize, here's what we've got. It's the truth. It's not going to change. That's why I can share it with you now. That's why I want you to know it now. Okay, if this goes to trial, and you don't put it that way, you let them come to that conclusion. If this goes to trial, you're going to lose. In a prosecutor's office, losing a case is an absolute humiliation. And in a civil lawsuit, you tell whichever young associate attorney is running that particular case, we're going to win. And he has to go back and tell the senior partners, whom he one day wants to join in the partnership, we are going to end up spending 6 figures of your money on prostitute experts to say what we want said, and they're going to destroy us anyway, and we're going to lose. Abort the mission, cut the losses. And they generally fold the tent and go, or offer a settlement so low that it's cheaper than going to trial and it makes sense to settle.
Well, and there's another aspect of that concern that I expressed about the family and the judgment in the neighborhood. And I believe, based on one of our, it's probably been a decade ago now, member-involved cases, and that is the attorney's willingness to engage with the public through the media, because it's very, very common. And I had a good friend who since has unfortunately passed, but who worked as an attorney. And he said, ironclad case, I don't talk to the press. And I mean, I understand his position because he was doing public defense work, and I'm sure he had many cases where it would have been catastrophic to have talked publicly, nor should he have. But what about the innocent person? Is it okay?
This is another classic example of, all attorneys are taught in law school what all cops are taught in the police academy.
Okay.
We don't discuss our cases in the press, it'll all come out in court.
Yeah.
That is in the nature of a treaty. It's understood both sides will not discuss the case. When the other side does a war in the press, and this for more than a decade now has been the changed paradigm, we saw, the classic example is the Zimmerman case.
Okay.
February 2012, the incident occurs in Sanford, Florida. The family of the young man knew who was killed, knew Trayvon Martin had been getting into trouble. That's why he was hundreds of miles north of his home with his mom where he lived, with his divorced dad. It was like tough love, I can't do anything with a kid, maybe you can. I don't think even they realized how much crime he'd Trayvon Martin had been getting into until the prosecution finally cracked his iPhone. But all they knew was our unarmed 17-year-old son is dead.
Yes.
They hired an attorney named Benjamin Crump, who describes himself as a civil rights lawyer. He in turn hired Ryan Jewison. Ryan Jewison, if you look him up, his webpage says he's available for litigation support. This takes the form of we'll demonize whoever it is you want to get money from. And he was the one who took the picture of Trayvon Martin at the age of 12 and juxtaposed it with the ugliest picture he could find of Zimmerman. Yes. And created the whole trope of the innocent child skipping down the street with the box of Skittles, and the evil racist guns him down to satisfy his bloodlust. Zimmerman was a 27-year-old kid, had never been in trouble for anything before. Was the duly elected captain of Neighborhood Watch. And he couldn't afford an attorney, and he kind of fibrillated there for a while. And with no one to answer that charge, you know, we've had the discussion. The false allegation that goes unanswered is seen as it must be true.
Yes.
Now, he won. The evidence clearly showed he was being violently attacked by Trayvon Martin, that it was self-defense, and the jury appropriately acquitted him. He is still considered one of the most hated men in America. Literally had to change his name and lives in hiding. Okay, and another mistake you see made is they'll address the first jury, the criminal element of the case. They'll address the second jury, the civil element of the case. I tell them you need to remember the third jury, the court of public opinion, the world this person and their family is going to have to live in after you've won the trial, after you've won the acquittal, after you've won the lawsuit. And if you end up like that, having to live in hiding for the rest of your life, it's a pretty hollow victory. Attacked, you need to respond. When the other side breaks the treaty no longer binds you. I want an attorney who's going to have the guts to call a press conference, stand in front of the camera when that's happening. Don't be the first to do it, but if the other side falsely accuses, then do it. And say, here's the truth, here's what happened. The case you just mentioned with here at the ACLDN, the member's name was John Dobb.
Yes, and he's spoken publicly, so we're really not telling any stories.
Violent home invasion in the morning with his wife and his kids at home. Wound up having to shoot the man who had broken in. It was a cross-racial shooting. The man he had to kill was mentally ill. And it was the perfect picture of the sympathetic decedent, which would normally be, oh my God, you gunned it down, blah, 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 without taking into account disparity of force, the violence with which that man had broken into his home, the fact that he had to protect his children, etc. He called ACLDN. ACLDN brought in Gene Anthes.
Yes.
Gene Anthes did a press conference on the lawn in front of the shooting scene before the blood was dry. And the public got both sides from the beginning. Now, any of these controversial shootings, if you look at the newspaper accounts, in the old days, letters to the editor, if they were crackpot or crazy stuff, the editor would just throw them out. Those things now are mostly unmonitored. And you look at the electronic comments in most newspapers, you'll see, oh my God, crazy, this is why nobody should have guns, blah, 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 crazy person killed poor innocent, blah, blah, blah. You go back and you look at the commentary on the Dobb case, there were some people saying, you know, and they always come out of the woodwork and say there's no such thing as a justifiable homicide. But the majority that I saw back then were, thank God he had a gun, how awful that poor man had to do that to save his family. Do we see a small, subtle difference here?
Yeah, we do.
Today, John Dobb and his family live normal, happy lives. And that is what I believe now has to become the paradigm. And I want an attorney who's got the guts that Gene Anthes had to stand up and address that third court, the court of public opinion.
Well, that's wonderful, because the alternative would be either a locked door that the press is knocking and no one answered. They're always going to say, we reached out, but no one would give us any answers, or some poor frazzled looking a homeowner coming to the door and saying, I can't talk to you. I mean, all of those things are pretty poor
It needs to be
solutions.
the attorney doing it, but you need an attorney who will do it.
Yes, yes, well put. Well, what other facets of this haven't we talked about?
I think we've pretty well covered it. Certainly have support. These things get very expensive. The Zimmerman's expenses went way over $1 million. In the Rittenhouse case, I took a lecture from his two defense
Oh,
attorneys,
nice.
and they both said it went over $1 million. And what paid for it was the donations of people like you watching this. And if you donated to that, God bless you for doing that. But that's what ACLDN was for. ACLDN literally founded the industry of post-self-defense support. It's the one I belong to, and I personally think is the best.
Well, thank you. And, you know, it bears noting that we affiliate with a lot of lawyers, and nothing that we've said today is in criticism of anyone who works in that field. I'm almost uneasy bringing up the idea of talking about mistakes that any profession makes. But I think that we have to be our own best advocate, much as if we went to a physician and they said, that organ needs to be removed. And I might think, yeah, I kind of use my spleen. Maybe I don't want it removed. What do? I go get a second opinion. And I think that we don't always take that proactive an approach when we're uncomfortable in a field. And certainly our interaction with the criminal justice system, most of us live the closest we ever come is going to pay our traffic ticket. I told you we shouldn't speed on our way to work this morning, Massad.
It's not my fault. You can't blame me.
Yeah, fortunately, he had somebody else pulled over. But if that's our only experience with it, or heaven forbid, divorce court or child custody court or that type of thing, I think that aversion is really natural. But at some point, we've got to be willing to speak up for ourselves and say, this is not working. This is not working. Now what do I do? And certainly we as the network, are happy to interface between the member and the attorneys or help get a second attorney, that type of thing. But ultimately that responsibility for ourselves lies with ourselves, and I think we've got to have that gut check and say, I don't think that this is in my best interest. I think I need to get some help.
You need to know what you need. You need to remember that the attorney works for you. At the same time, all of you that are watching this are alpha males or alpha females. You're used to being the one who protects others. You're used to being the shot caller. You're used to making the decisions. Once the trial is going, understand you're not the player anymore. You're the stakes. The attorney is the player. You want the best damn player of this game that can be found. And that's not necessarily the most famous criminal defense lawyer. It's going to be the best, most experienced affirmative defense lawyer who can get the truth across to the jury.
Excellent. Thank you. Good summation. And I think you just said on tape that I'm bossy. Thank you, Mass. Good as always.